Week 5 of the New York Attorney General's civil fraud trial, but it was day 1 of Don Jr.'s testimony. Donald Trump was not in attendance like he was when it came to Michael Cohen's testimony. Don Jr., during his testimony, just couldn't remember a lot of things. He couldn't recognize the document that he signed that made him in charge of the Trump organization. I don't know, you'd think that would be a pretty important document. Don Jr. claimed he didn't recognize the 2017 statement of financial condition that he was responsible for as a fiduciary. You'd think that would be something important as well. Don Jr. also said he was unaware of generally accepted accounting principles, and that's why he pays people millions and millions of dollars. Okay, Don Jr. And he didn't even know how it came about that Alan Weisselberg, the CFO, no longer was the co-trustee. He knew it happened, but how did it really go down? There you go. That was day 1 of Don Jr.'s testimony. Also, it's been week 1 of the Colorado state constitutional disqualification case against Donald Trump. The judge presiding over the matter denied Donald Trump's motion to dismiss. It's called a motion for directed verdict after the petitioners rested their case. And then guess who Trump called? Kash Patel. And guess who Kash Patel blamed? Bill Barr and the FBI. He said they were responsible for the insurrection. Look, folks, it's complete bogus. It's completely wild and outrageous, but what else would we expect? These constitutional disqualification cases are heating up across the country. For example, in Michigan, where this week Donald Trump filed a lawsuit to try and block the Secretary of State there, Jocelyn Benson, from removing him from the ballot, a preemptive move by Donald Trump seeking injunctive relief. We'll talk about that. Also, 2 federal judges, 2 entirely different rulings in the same day today on handling classified information in the federal criminal prosecutions of Donald Trump. Judge Cannon came up with her own interpretation of CIPA, the Classified Information Procedures Act. And Judge Tanya Chutkin, on the other hand, in Washington, D.C. federal court, followed, I don't know, the well-established law about CIPA, Classified Information Procedures Act. One question that I have following that hearing is, will special counsel Jack Smith, though, now bring an appeal when it comes to what Judge Cannon's been doing? There was a hearing that was held today as well before Judge Cannon in the Fort Pierce division, where Judge Cannon says, I don't know, I think we're going to have to delay this things. But in typical Judge Cannon fashion, didn't actually make an order doing that. All of her dates and deadlines have been blown. She stayed her own deadlines. As I've said, her corruption is matched by her incompetence. And then let's talk about what went down earlier this week, although I don't know how you feel about it, Popok. It feels like a year ago. I had to look. I was like, so this happened a few days ago? It did. When federal judge Tanya Chutkin reimposed her gag order on Donald Trump, removing the temporary stay of the gag order. And one of the things she cited in her order were Donald Trump's threats of witnesses, like his former chief of staff, Mark Meadows, who Trump referred to as a coward and a weakling. How embarrassing can you get? But folks, great to know that the wheels of justice are turning and turn in the right direction. This is the midweek edition of Legal AF. I'm filling in for Karen Friedman-Agnifilo, joined by Michael Popok. Karen Friedman-Agnifilo will be back. Don't you worry, but I'm going to do my best to hold down the fort. We miss Karen Friedman-Agnifilo. She's the best. And by the way, her hot take, her duet, as we call him, with Danya Perry, former federal prosecutor, Michael Cohen's lawyer, was fantastic. I'm looking forward to many, many more of those duets together of Danya Perry, Karen Freeman Agnifilo, two of the top former prosecutors, not just in the country, in the world, right here on the Midas Touch Network. I love it.
Well, I'm glad you're filling in. And for those out there, I'm a little under the weather. So I've asked Ben, as you can see, he's pepped up today. I've asked Ben to do the intro, but I'm here. I'm going to pull my weight. As always, I will rally. I've coughed my way through a number of hot takes, but I will survive. You know who's not going to survive, Ben? Is the Trump organization in this civil fraud case. I'm going to give one comment as a practitioner of law in New York, worked for major corporations. That's me. There's the problem that they have, the kids, is that they took jobs, not just make work jobs, but control officer jobs, jobs that make them responsible for the financial controls of the company, for the to be the control officers, meaning for compliance purposes and for everything related to how that business is supposed to operate consistent with the laws of the state of New York. And all we're seeing, whether it's Don Jr. today, the start of Don Jr. today, Eric eventually, Ivanka after Donald, or Donald, is a Donald Trump at best put lackeys, inflatable dolls, children with no experience or no interest in key control positions that which they were either ill-suited for, had no qualifications for, fell asleep at the switch, or busy pointing the finger at who, me? I was responsible for that. I thought he was responsible for that. That does not fly in the business capital of the world, New York, and how you operate a business. And all it's doing, they think what they're saying is, I wasn't responsible. I'm not an accountant. I'm not a this. We know what you are. We know you won the Lucky Sperm Club. But the point is, in order to operate a business that's public facing in the state of New York and that transact business, you have to have proper qualified people in control positions. And all we're seeing is that ain't what happened at the Trump organization.
And when we talk about the revocation of these licenses, almost think about it like a revocation of like a driver's license, right? If you are someone who has a DUI or someone who's impaired, or if you're trying to be a truck driver and you don't pass those types of tests, right? Your license gets revoked or you don't get the license in the first place. So where you are driving a truck and you don't have your truck license, you're not allowed to do that. In essence, if you want to simplify what this New York Attorney General civil fraud case is about, one major element is that it's basically being showcased here, right? Where the Trump kids show up to testify and they didn't know how to drive the truck. That's part of what essentially the claim is, that you were fiduciaries. These statement of financial conditions were made where you were responsible for it. The buck stops with you, and you don't know anything about the statement of financial condition, in which case you are either lying or you are so willfully negligent and reckless, showing a callous disregard for the financial markets and for everything, that you should have your license revoked. And that was so clearly on display for Don Jr.'s testimony. Now, today's testimony of Don Jr. only lasted about an hour. It's going to continue on tomorrow. Lisa Rubin, a lawyer and reporter, was there in attendance, and she's been doing a great job live tweeting this, or live Xing it, whatever the heck you call it, today. And here's how she basically described what went down. That early on, Don Jr. described what his role was during the 2011 to 2017 time period as a, quote, all-encompassing developmental role, he said, involving international deals, financing, leasing, licensing. But after 2017, things changed. And there was no one above him when he began to function as a trustee of the Trump Revocable Trust, which oversees all of the Trump entities, all of those LLCs. The ultimate authority post-Trump inauguration was held by Eric, Alan Weisselberg, who's now a convicted felon, and Trump Jr. And then Weisselberg is no longer a co-trustee. He was removed when he was indicted, although Don Jr. said he didn't know who specifically removed Weisselberg. Now, just think about that in and of itself, that Don Jr., one of the co-trustees, claims to not know how the other co-trustee was removed, how it went down, how that decision was made. That's something pretty basic. Or how about the fact that when Don Jr. was provided the document that made him a co-trustee, that gave him the power of attorney, how about when Don Jr. got that document? He claimed he didn't recognize what that document even was. And the New York Attorney General lawyer had to say, but that is your signature right there. Or how about the fact that Don Jr. claims that he had no role or involvement and didn't even recognize the statement of financial condition for 2017? That was the first one he was given. So tomorrow, we could expect that he's going to be shown 2018, 2019, so on and so forth, and he's going to respond the same way, that he doesn't know what the statement of financial conditions say. He's going to say, I just relied on the outside accounting firms. I relied on Mazars. I relied on Donald Bender, and I relied on Alan Weisberg. I don't look at the statement of financial conditions. Well, you know, Popok, how the MAGA-splainers out there like to say all of these things like, let me tell you how business really is, Ben. Because you see, Ben, the property appraisal is always so much lower than the fair market value. You don't know anything about real estate, Ben. And to which I go, you do realize that the valuation of Mar-a-Lago was set by Donald Trump. Like, you do realize that Trump's vice president, Raymond Flores, who's testified, was the one who said on behalf of the Trump organization that their valuation, because they checked the box that it was a commercial property, not a residential property, and had all of these encumbrances placed on it based on a mid-1990s deed that was executed to lower all of their property taxes, that the valuation was less than $27 million. And no, MAGA-splainers, I've never heard of fair market value being 3,000% more to 5,000% more than the property appraisal that was done by the tax assessors, for example, from Palm Beach County. So to all of the MAGA-splainers also, I've also never heard someone who's supposed to be the head of a corporation who doesn't even know the contract that they signed that made them the head of the corporation, or who hasn't looked at their statement of financial conditions. So MAGA-splainers know, and this is the thing, Popok, it's this incongruity of what the MAGA-splainers say when they go on their podcasts and their right-wing shows versus what goes down in court. And that's what we saw just during that sliver of Don Jr.'s testimony today. What did you take out of it, Popok?
First of all, there's an admission by Donald Trump that he lost the election. That hasn't been overly reported. On January the 15th, 2021, Donald Trump put himself back in as trustee of his trusts. You only do that if you know that you've lost the election. If you think you've won the election, which he keeps claiming, that's not the behavior and conduct of somebody who thinks that he's lost. That's the behavior and conduct of somebody who knows that he's lost and that he's going back to take control of the company from his 3 ne'er-do-well children, who, fortunately for Donald Trump, didn't completely, based on the brain power that I've been seeing during the trial, didn't completely grind this company into the ground. They are not their father's equals. Say what you want about Donald Trump, but he knew how to take his father's existing business and at least maybe double it over time. These kids, with their lack of business approach and acumen, Donald Trump couldn't wait to get back into the saddle. So that's one. Secondly, all the things you just said about, I thought we've developed a new drinking game, MAGA-splaining. Everything that you just said about property value is so true. What the New York Attorney General has said time and time again in her daily press reports that I love the fact that she posts on the Office of Attorney General website a daily explanation of what just happened in court. That just shows you how confident she is. I've done trials for 32 years. I've tried over 40 cases. I don't get the luxury of every day having a press conference. Here's how I did in court today. Here's the 3 witnesses that really went well for me. I mean, it's really great. But what she said and outlined it is that Donald Trump, in valuing his property, he manipulated it in different ways. But the consistent theme is disregard for law, government regulation, zoning regulation, easements, and anything, and economic reality. And then he values his property. For instance, Mar-a-Lago, he acts like it's a single family home on 15 acres that's not burdened by a conservation easement that he placed on it in order to agree never to develop it in order to get lower taxes. In Scotland, he acts like he can develop thousands and thousands of homes on his Scottish golf course property when the most anybody has ever on the government there has ever thought to approve is 500. So he just says, let's act like I can do 5,000. Well, but you can't. Let's act like there's no conservation easement in Mar-a-Lago, but there isn't. Let's act like a Trump building in New York doesn't have rent control apartments in it and value it as if it does or doesn't. But you can't. So, that's why he can stand in front of a bank of microphones with a bunch of people who really don't know the facts and say that, look at Mar-a-Lago, that's got to be worth $500 million, right? Look at it. No, not given the reality of it. And all I'm seeing with people like Don Jr., and I'm sure it's not going to improve with Eric Trump, are people who are out of their depths, who either because they have rich person syndrome, rich boy syndrome, rich playboy syndrome, where they were born, to paraphrase the great it'll come to me in a minute, the great Texas governor who said that George Bush was born with a foot in his mouth. They were born with a silver foot in their mouth. And that's the only reason they get to sit there. But they're not qualified for the position. They have no interest in the job. They're just rubber stamping and signing things. They don't know what's going on. But which is bad. You can't, as I started the segment with, you cannot operate a New York business with a bunch of inflatable dummies, crash dummies sitting there as your control officers who have no interest or acumen or ability or capacity or bandwidth to handle the job title that they are given. Doesn't matter if their last name is Trump. That doesn't qualify them for the job. And Donald Trump didn't care because he didn't want people to be control officers, to push back against his grandiose ego and how he ran his business. Because he ran his business like an out of control mom and pop organization without regard to third parties like lenders, insurers, investors, buyers, government regulators, or anybody else, which is fine if you just want to, not go for, if he'd ever wanted to go for a bank loan, just had his own money. Some family offices never take out loans. They have so much wealth that they're able to fund everything they want to do. If you don't have to go to the bank, if you don't have to go to insurance companies, if you don't have to go to investors, if you don't have to do these things and be public facing and have counterparties that are not you, that are not relatives of you, then you got to play by the rules. And the rules in New York are very strict when it comes to business operation. That's why many companies don't incorporate in New York. Not that Delaware is any better, but he wanted that. He inherited his dad's business. He wanted the cachet of being a New York company. And with that, then you must know, Donald, I did a hot take on this a long time ago, that in 1956, the New York legislators, led by, at the time, a attorney general of the state, passed the 63-12 persistent fraud laws. Since 1956, they've been on the books, and they've had the power to, if the remedy is appropriate as fashioned by the judge, to disgorge, meaning take back, claw back ill-gotten gains, regardless of whether there is a quote-unquote victim. Chris Keiss, the lawyer for Donald Trump, when he's not busy trying to figure out how to also appear in the Mar-a-Lago case, we'll talk about that next, he doesn't understand New York law. He doesn't understand that a Trump case from 2016 involving the then Attorney General Eric Schneiderman shutting down Trump University as a bogus whatever, approve the use of disgorgement. That has been on the books as a power forever. And it doesn't require materiality. It doesn't require reliance. It doesn't require victims. All it requires is that you did underhanded business conduct for which you got a benefit, even if the other person doesn't care, didn't mind, wants to be in business with you. I'm okay with being ripped off. It doesn't matter. So parading a bunch of witnesses like Deutsche Bank to say, well, I relied on the statement of financial condition, but I like Donald Trump and I would have lent him money because I think he's a good credit risk. It doesn't matter. And he's been told this by, and this is where Engoron is getting frustrated and acting out, which is fine with me. He's been telling this team of Haba and Kais and Clifford, whatever his name is, for the last 6 weeks, since they've been raising it in motion practice. Do you understand that I can find persistent fraud without intent? You can accidentally commit this kind of fraud in New York. Do you get that? And that's how summary judgment got granted. On the rest, different story. Do you get that I can take, and he's already said, this is the scary parts. If you're listening to the judge on Trump's side, think of the things, Ben, that he's already said aloud that indicate that he's made up his mind. One, there is enough evidence in this room, right, to on the persistent fraud to fill this courtroom. So I don't really care. I like what Michael Cohen said. I'll listen to it, but he's not the only witness. That's one. Two, he told them when they started to attack the ability to take away all their buildings and property and companies, he said, I've already found ill-gotten gains. That's terrible for them. He's already, then he's just listening to the experts from the Office of Attorney General side to figure out how much of the ill-gotten gains, how you calculate the amount that Donald Trump benefited because of his fraudulent business practices. That's all they were doing before Donald Trump took the stand. So you have that, the comment about that. And then the comment where he said to Mr. Kais, you don't understand. I have this power. I have found ill-gotten gains already. And it sounds like you were whistling past the graveyard, which is an old New York phrase that my grandfather used, which means you're really nervous about bad things happening. So you whistle so that you make yourself feel better. And it sounds like, Mr. Kais, you were whistling past the graveyard. My view, Engoron is waiting for everybody to stop talking. Get all the evidence in. Looks like it will probably be before Thanksgiving, probably a month early. And I think I said this on a hot take. He's got this order substantially written and just sitting in his computer to be finished with additional evidence and footnotes, yes, and references to exhibits and testimony, yes. But he's got it half written, and he's just waiting to print and send as soon as the lawyers stop talking.
You know, normally in a situation like this, if your clients were confident in their case, we would expect to see what are called disputed facts, right, from people like Don Jr. and Eric and Donald Trump, so they can cite to, here are the disputed facts. Here they're saying this is what the statement of financial condition said. Here's why it was structured this way. And yes, there may be a vice president of the Trump organization who's saying this. And yes, the outside appraisers are saying this. And yes, the accountants are saying this. But we dispute that. That is wrong, because look at what Don Jr. is saying. That's not what we have here. We have Don Jr. being presented with a statement of financial condition. Saying, I don't know what that is. Ask Eric. Eric looks at it and goes, I don't know what this statement, that wasn't my job. I was just pouring concrete. You go to Donald Trump and he goes, yeah, that was Alan Weisselberg's job. You go to Alan Weisselberg, he goes, yeah, you know, I'm not a CPA. I'm just a bookkeeper. I don't really know any of this. So you have all of that on the one hand, and then you have, setting aside the state's evidence, you have the Trump insiders, all of the other ones who are saying, yeah, that's fraudulent. Yeah, we inflated that. Yeah, I was told this. So when Judge Engoron granted summary judgment for New York Attorney General Letitia James, it was based on undisputed facts. And Judge Engoron doesn't hate Donald Trump. Judge Engoron is not a Democratic operative. Judge Engoron is someone who looks at the facts, who looks at the evidence, who looks at the law. And for me, Popok, what angers me the most is just the gaslighting, is just knowing how Trump and the MAGA splainers do one thing in court, and then they just go out there with impunity and act and play a part and prey on the fact that some of this stuff could be a little bit complicated if you obfuscate and confuse. That's why we've made it our mission here at LegalAF to cut through it. Just give me the facts. Give me the evidence. Okay, that's what Don Jr. said, and you're going to mag-explain to me that that's supposed to be the brilliant head of a corporation who doesn't review their statement of financial conditions and doesn't even know the contract that empowered them to lead? You
And
ain't going to convince. You ain't going to convince. No, it's purposeful.
Yeah.
It is persistent fraud. You mentioned
Correct.
Chris Kice, though, Popok, because he's kind of 2 cases or 3 cases or 5 cases all at the same time. He, and by the way, one of the things is he may be wishing he didn't take that $3 million from Donald Trump. Trump paid him that lump sum through the Political Action Committee. And now Trump basically has. Now Trump, he should have charged 10. I bet you that's what Kice would say privately, because now Trump has Kice doing everything. I bet you just at that lump sum fee. So while you had the case going on, the civil case in New York, you had Kice appearing telephonically or through Zoom before Judge Eileen Cannon at a hearing today to try to where she wanted to determine whether or not she was going to delay all of the dates that she set. She's already stayed her own dates. Like, she basically ruled against herself. She stayed her own dates and deadlines indefinitely. And then about 10 days ago said she was going to hold a hearing on whether to then further delay everything and to alter the existing trial schedule. And where she's kind of trapped, Popok, and we've done some hot takes on this, and I'm going to do another one, is she's trying to help Trump, but what she realizes is that if she moves that May trial date, you're going to have the Fulton County District Attorney Fani Willis swoop in and try to ask Judge McAfee in the state court Georgia criminal RICO case to set that trial in May of 2024, now that Ken Chesborough and Sidney Powell pled guilty. So now you have Judge Cannon. She just kind of created this Rubik's Cube of confusion and disorganization, and she doesn't even know what to do. So she left this hearing just basically saying, all right, I'm going to figure out what I'm going to do in a little bit, but I'm inclined to delay the dates, but I'm not going to tell you if I'm going to do that. And Kice appeared on that one. Tell us.
Nobody. Well, first, let me comment on the trial things. We've talked about this before. No one has respected Cannon among the other judges. Let's just put that out there. We have our own criticisms, some harsher than others, about Judge Cannon, a first-time judge handling, what is one of the most historic trials of a former president ever. And other judges just don't respect her. We had Judge Chutkin, in her big, huge DC election interference case, look at the calendar and go, I'll take March. Without saying, well, what about the May case in Mar-a-Lago? Yeah, do I stutter? I take March. And her case is going to go longer than 2 months, so we'll leave that for a minute. But also, as we said, and you said, when we were analyzing the way the clearing out of the calendar in Georgia would go, that Fani Willis is chomping at the bit to get a Georgia prosecution trial of Donald Trump in 2024, well before the election. And the dance card just opened up, and they're just ignoring her. And if Fani can't go, then you're going to see Stormy Daniels' hush money cover-up case, business record fraud case against Donald Trump by the Manhattan District Attorney, who's still technically scheduled for March, the same time as Judge Chutkin, slide in as they're like, okay, Cannon, you're out, we're in. There's 2 backups. I mean, you and I who practice trial law, judges often set what we call backup cases. They got the trial set for one trial setting, but they take backups because cases settle. And I've been a backup. I've been the number 1 backup. I've been the number 5 backup. And you're like, oh, great, 5 backup. I'll never go to trial this month. And then you get a call from the clerk. Okay, the 4 cases ahead of you just settled. You're in. Like, okay. So that happened. So the backups here were not done intentionally by one judge. These are multiple judges, but they're all hovering. This is like, they're all out there with the flight plan hovering around. And as soon as she pulls out cannon and goes, because you can already see the writing. The writing's not only in the wall, it's in her order where she's going to reset the trial date. Well, she's going to reset the trial date. 2 more are going to jump on top of it. So if Donald Trump thinks he's going to lose, he's going to win by not having this trial, I say Jack Smith has won, because for the longest time he's been able to use Mar-a-Lago to exhaust the resources of Donald Trump, to spread his counsel so thin you could see through them. I mean, that's how thin this staffing is. There's times when Chris Kice can't run down to appellate court and argue in an appellate court, so he's got to get a delay in the New York case, and now he's got to ask to phone into Florida, and Jack Smith's just sitting there going with his 250 lawyers and staff and investigators and an unlimited budget for the United States of America against what I said in a hot take is literally a total of 6 lawyers, not law firms, 6 lawyers for Donald Trump up against all of this in 7 cases in 9 months. That's why in Colorado, we don't even know who this lawyer is. We'll talk about the Colorado 14th Amendment case. We don't even know who this lawyer is for Donald Trump. It's not one of his usual suspects, because they're all pinned down under heavy artillery in these other cases and they can't move. I mean, Donald Trump could lose. I don't want to keep repeating this, but let's beat the dead horse one more time. He's going to lose his buildings, his money, and his business operations in New York if Alina Habba and Chris Kice aren't successful. Who's a betting person out there? Who's going to put the office of the Attorney General, which I've been against, including recently, against these 2 on these issues with this judge who's already made his rulings, basically out loud. So you're better at the SEPA stuff than I am.
I'll go over the SEPA stuff too.
SEPA.
Alina Habba was overheard, though, in the elevator, speaking to Donald Trump, saying, "Don't you worry, sir," because Donald Trump likes to be cool. "Don't you worry, sir. I'm going to go give him hell today."
Oh,
I mean,
she was never heard from again. She didn't talk today.
She definitely didn't talk today. So just a quick refresher on the Classified Information Procedures Act. This was a law that was passed by Congress back in 1980. There's not a lot of things that are controversial about SEPA. The cases themselves may be, because they involve situations where a criminal defendant usually has stolen classified documents, or that classified documents are involved in the case, and they have to be handled differently than even confidential records. So SEPA is this regulatory regime, well established. How do we handle classified documents and information? It would be easy to even teach a class on this. That's how well established this is. So when Donald Trump's lawyers say, under SEPA Section 4, we as the defense lawyers should get access to the briefing and all of the classified information, maybe not our client, but the lawyer should get access to it. It's not like a difficult question, Popok. The answer is no. You don't get it, because the procedure is supposed to be something called ex parte and in camera, meaning you don't get to be there, defense lawyer, because Congress, not Jack Smith, not President Biden, Congress in 1980 said that when we deal with classified information, we want to protect against situations where criminal defendants will blackmail or graymail the government and basically say, hey, we're going to take these documents, these national security documents under the 6th Amendment, we're just going to broadcast them publicly. So screw you, United States of America's national security, or maybe you just want to drop the charges against this. So SEPA tries to protect against that. That's why the lawyers for the defendant don't get access to certain documents that are deemed so highly classified that they go through this Section 4 procedure. So Donald Trump's lawyers In both cases, one to Judge Cannon, one to Judge Chutkan, basically said, we want to be involved in the process. What do you think Judge Cannon said? Maybe, okay, that intrigues me. Maybe you could be involved. Maybe SEPA Section 4 doesn't say what SEPA Section 4 actually says. I'm just going to have the SEPA Section 3 protective order be the thing that governs here. And I don't really think I'm even going to follow SEPA Section 4 in this situation. It's like, what do you mean? You don't really have a choice. It exists. SEPA Section 4 is a thing. And then you had Judge Chutkan basically in 5 pages, whereas Judge Cannon took 15 pages. Judge Chutkan's like, what are you even talking about here? This couldn't be clearer. This is what Judge Chutkan says. At the outset, it bears emphasis that the defense identifies no case in which any court has ordered the relief they seek here. That should be changed now because Judge Cannon just did that. And this court is aware of none. There is good reason for that lack of precedent. As SEPA's House report explains, since the government is seeking to withhold classified information from the defendant, an adversary hearing with the defense knowledge would defeat the very purpose of the discovery plan. Rather than undertake that unprecedented and likely futile course, the court will instead follow the well-established procedure of holding an ex parte hearing with defense counsel to better understand whether the withheld information is relevant and helpful. That process, not adversarial litigation, is the appropriate course for resolving SEPA Section 4 motion here. Salty, if we have the chart on the SEPA funnel, if we're able to kind of pull that up here, because if I were just to teach a course to second-year law students on SEPA, I would show them this SEPA funnel that justsecurity.org published about how the process works. This is how well established it is. So if I could just make it clear what Judge Cannon did, she basically put an X through the Section 4 of SEPA part of this funnel. And she's acted like she's so self-important, like she conducted her own statutory analysis and said, well, Section 3 mentions both the defendant and defense counsel, but Section 4 only mentions the defendant, not defense counsel. Therefore, I think that the congressional intent in 1980s, that's not your role as the district court. Just follow what the freaking precedent is. And if the judge is supposed to look at things in camera and ex parte, by its very nature, that means that the defense lawyer is not there. So anyway, that's what Judge Cannon did. But the good news here, I think that this is actually the first opportunity that special counsel Jack Smith has to appeal something that Judge Cannon did, because all of our other orders were really not appealable orders until this one. So I'm going to be taking a look at what special counsel Jack Smith is doing there. By the way, we've got a lot to discuss on this episode, including Popok, the disqualification trial in Colorado, a lawsuit by Donald Trump in Michigan to try to block disqualification cases there. Also, let's go back to Judge Chutkan reimposing the gag order that she had temporarily stayed as Donald Trump started to threaten witnesses again the moment that the gag order was stayed. Also want to remind everybody, we've got a full house here. We are, again, one of the most watched shows, not just in the genre of news, but of all genres, not just here in the United States, but across the world. So if you want to support this independent journalism, you can do that now by going to patreon.com/MeidasTouch. That's patreon.com/MEIDASTOUCH. You see some of the critical reporting that is being done by our team. Our reporting led to a gag order violation being found against Donald Trump in the New York Attorney General civil fraud case. Then Donald Trump and Don Jr. came and attacked the Meidas Touch network. So if you want to see the impact that we're having there, that should be Exhibit A. That's patreon.com patreon.com/Midas Touch. And we just had our Zoom meeting where we met everybody. So if you are a member of our Patreon, please put in the comments below how you feel about the content that we have there at patreon.com/Midas Touch. And if you think all of the exclusive content that we offer is worth it, I'd appreciate it if you share it, just in case people are on the fence. We will be right back after our first quick break.
I am so thrilled to talk about LegalAF's latest exciting new sponsor, Copilot. Copilot is a personal training app that was listed by Forbes as the top-rated personal trainer app of 2023, and I can see why. I've always wanted my own personal trainer, but I've never been able to find the time in my schedule, whether it's about work or family and all the things going on, to have the time to work with one. I also don't really like going to a gym, but I do know how important exercise is, and I like to exercise and want to incorporate it into my life and my daily routine much more. So if you're a woman like me of a certain age and you know how important it is to maintain healthy bone density and strength training and keep your heart rate up through cardiovascular exercises, that is something that we all have to do. And it's important to find the time and the ability to do that in your life. And Copilot is the thing that has helped me do that. And I'm so excited and thrilled to have someone from the comfort of my own home who I can video chat with. She's my own personal trainer, and she can help me. She has helped me develop a routine that fits with my lifestyle, incorporates exercises that are things that I like doing, that are easy for me to do, and that are fun for me to do. And she also helps hold me accountable because I know I'm going to be, she's going to be seeing and tracking my progress and seeing how I'm doing. And that has really helped me stick with my program. So it's fantastic. It's so much more than just a fitness app. There really is this personal connection and these personally tailored exercise routines that are good for your body, your lifestyle, and your goals, your fitness and body goals. So head to go.mycopilot.com/LegalAF to get a 14-day free trial with your own personal trainer. That's go.mycopilot.com/LegalAF to get a free 14-day trial with your very own personal trainer and take a back seat and let Copilot help you reach your fitness goals.
Did you know that poor sleep can cause weight gain, mood issues, poor mental health, and lower productivity? Sleep is the foundation of our mental and physical health and performance in our days. Having a consistent nighttime routine is non-negotiable. When I don't get enough sleep, trust me, you don't want to be around me the next day. Introducing Beam Dream. You know we've been raving about Beam's Dream Powder, their healthy hot cocoa for sleep. And today, our listeners get a special discount on Beam's Dream Powder, their best-selling healthy hot cocoa for sleep with no added sugar. Now available in delicious flavors like sea salt caramel, cinnamon cocoa, and chocolate peanut butter. Better sleep has never tasted better. Dream contains a powerful all-natural blend of reishi, magnesium, L-theanine, melatonin, and nano CBD to help you fall asleep, stay asleep, and wake up refreshed. A recent clinical study revealed Dream helped 93% of users wake up feeling more refreshed, and 93% reported that Dream helped them get a more restful night's sleep. Just mix Beam Dream into hot water or milk, stir or froth, and enjoy before bedtime. I've personally tried Beam Dream, and it lived up to the hype. First off, it was delicious and just a lovely nighttime routine. And secondly, and most importantly, it helped me fall asleep and stay asleep. The next day, I woke up ready and eager to take on all of life's challenges and tasks. Find out why Forbes and the New York Times are all talking about Beam and why it's trusted by the world's top athletes and business professionals. If you want to try Beam's best-selling Dream Powder, take advantage of their biggest sale of the year and get up to 50% off for a limited time when you go to shopbeam.com/LegalAF and use code CYBER at checkout. That's shopbeam.com/LegalAF and use code CYBER for up to 50% off.
Welcome back to Legal AF, a full house here live. And, we're just breaking down the key legal issues of the week. Michael Popok, Ben Meiselas. I'm filling in for Karen Friedman-Agnifilo on this midweek edition. We wish Karen well and excited for her to come back hosting these midweek editions, and also for some of her duets that she's been doing with the great Danya Perry. Pretty great stuff that we were able to host that stuff on the Midas Touch network right here on the YouTube channel. By the way, make sure you're subscribed to our YouTube channel, and also make sure you're subscribed to LegalAF on audio, and that you leave a 5-star review on audio. It's super simple. You just search LegalAF on whatever audio podcast device you use, and you hit subscribe, and you get the audio wherever you are. If you can do that, that would be great. Just search LegalAF. Let's get back into it. Popok, Judge Chutkan reimposing the gag order. She temporarily stayed it. Why do you think she did that, number one? And then number two, she removed the temporary stay after taking some briefing by special counsel Jack Smith and by Donald Trump. And one of the things that she cited and that she said is, she goes, look, I've made it very clear. You want to go after the DOJ, you want to go, you want to go after President Biden, you want to attack the government, you want to do things like all good, but you can't attack the special counsel. You can't attack witnesses in this case. You're not above the law. And while there are important First Amendment considerations that exist, criminal defendants can't engage in witness tampering. And as further evidence, though, that just the conditions of release are not enough, one of the things Judge Chutkan cited is, look what happened when she almost was able to prove by granting the stay how effective that the actual gag order is. She goes, look when the conduct stopped. Mm-hmm. I issued a stay. And then, boom, you start attacking Mark Meadows, one of the key witnesses here, and call him a weakling and a coward. No criminal defendant would be able to engage in that conduct. Popok.
Thanks, Ben. There's two traps that Judge Chutkan set for Donald Trump that he stepped into. The first was, rather than have him run off to the appellate court, the DC Court of Appeals, and try to argue for a stay there on a fresh record where he'd be able to litigate over the issues with briefing and delay things. She said, oh, okay. Why don't we do this whole litigation right here? In fact, you want a temporary administrative stay for a short period of time? I'll give it to you, because I have a feeling this is her inner thoughts here that I'm expressing. Because I have a feeling you're going to violate it during it, and I'll be able to use it in my order when I reimpose it. No, I'm not making this up. That's one. Two, let's litigate it here. And why is that important? That's important because the standard of review that the appellate court is going to use for the decision to reimpose the gag order after full briefing and a hearing at the trial court level is a very liberal abuse of discretion standard, which gives a lot of deference to the trial judge. If they didn't have the proceedings below, as we call them, in the trial court level, and it just went up at the appellate level, they would either send it back down and let the trial judge do it, or if they did it, they would do it on their own, which they don't like to do. They don't like to have a record that's not yet fully developed. So by having it fully developed, now when he takes the inevitable appeal to the appellate court and says, oh, I got the gag order reimposed, now they apply a very liberal standard that gives great deference to the trial judge and say, yeah, she didn't abuse her discretion. There was a full hearing, there was briefing, she cites the right law in the right way for the right propositions. How novel, because Donald Trump often cites no facts, law that doesn't support his position, and ignores entire bodies of law that he should be citing. Let me just say this for those that are only learning about the legal profession through, I was going to say through LegalAF Law School, but through the Trump lawyers. We have an obligation as officers of the court, all of us that have taken an oath to represent the bar, be members of the bar in that honorable profession, that if you know there are cases that are against you or that cases that support, you're supposed to cite the cases properly. And if they don't stand for the proposition that you say, it's a problem in terms of being an ethical advocate. And if you know there's a case contrary to your position out there, you need to bring it to the attention of the judge, not wait around to see if the other side catches it, or the judge's law clerk catches it, or the judge herself. And so we don't see any of that with the Trump lawyers. There's a reason that they never, when they're addressing the gag orders in any court, they never want to list or put on a spreadsheet or an Excel or a schedule, a list of all the things that Donald Trump said and compare it to the case law about that type of First Amendment speech when it runs up against the Sixth Amendment right to a fair trial, and the friction that happens when First Amendment speech outside the courtroom interferes with the proper administration of justice inside the courtroom. And that's the friction that this judge is living at. And she has made clear-headed decisions, bright line, about the application of precedent and law in the circuit at the Supreme Court level about these issues. There's a reason Donald Trump, just like we talked about it in the case in New York, doesn't want to come right out and say, look at these 19 things that I did and said about prosecutors and their family and judges and their family and staff and their family and all of it. And Jack Smith's a thug and his wife's a thug and his daughter's a thug. There's a reason they don't want to put that all in one compilated place. It's because it's terrible for them. It's easier for them to try to dispatch it, like John Lauro said in the hearing when the judge says, are you denying that there's statements that your client makes that leads to that violent rhetoric that exhorts his supporters to do really bad things like pick up guns and try to hunt for Obama in his neighborhood? Or she was nice. She didn't mention the person that called to assassinate Judge Chutkan and left a message. Or what we just heard about Fani Willis, in which Fani Willis and the feds have indicted the person now, a guy from Alabama who left on the customer service line, because that's where you leave death threats, at the Fulton County Government Center, a death threat against the sheriff and Fani Willis, who wears a bulletproof vest to work because she indicted Donald Trump. And she said, you're not going to acknowledge that those real world consequences have happened? And Lauro said, they're irrelevant. Right. He just waves it away with an irrelevant to his, what you're hearing, this constant bleating, B-L-E-A-T, bleating by Alina Habba and all the lawyers about First Amendment. But he threatened to kill somebody. First Amendment. But he threatened to hang somebody. Well, First Amendment. Well, he threatened to, hang the chairman of the Joint Chiefs of Staff. Well, the First Amendment. And that it just shows it's a juvenile Tourette syndrome that they've gotten, where they just think by saying the magic words like Beetlejuice, First Amendment 3 times, something positive is going to happen. And all it shows is a complete lack of the jurisprudence around the intersection. We talk a lot about intersection on this podcast, the intersection of the First Amendment and the other branch of government, which is the judicial branch, which deals with the court system. And you can't say anything. And that is what the Judge Chutkan has been saying since the hearings 2 weeks ago to John Lauro. You're not taking the position that your guy can say just anything, right? And he said, no, Your Honor, I'm not saying that, right? So he already established that. And the second trap that she laid is the one that you outlined, Ben, and I touched on, which is she, as you said, she ever so slightly lifted the stay for 2 weeks to see what was going to happen. And what happened was a perfect example that she could use to prove her point that his First Amendment rights are not gagged, that he can continue to campaign for the highest office in the land, God help us, without being gagged. He can attack Joe Biden. You gave the list already. I won't repeat it. You can attack all the things that you want to attack. You can say you're an innocent man. Okay, you can sing it like Billy Joel. However, you can't go after by name individuals and threaten them to try to change their testimony, because there's a statute on the books about that makes that a crime. And so the judge at the end said, here, let me give you 2 examples in my order that will show you what is right and what is wrong. Here, this one you said in early October. This one doesn't violate the gag order. You want to attack everybody here? That's fine. Now, let me show you one that you did during the 2 weeks when I lifted the gag order. And I love the one she picked. It just shows such confidence of her. She picked one that has tremendous racist dog whistle overtones in it, because Donald Trump is using that new term he just developed, which is short for another term that I won't say, called riggers with an R. The riggers have rigged the election. The rigger, we should go after the riggers. And then he throws dogs in there, dogs and riggers in the same paragraph. And she says, that one and the one where you go after Mark Meadows to try to influence his testimony, that one you can't do. Actually, I'm sorry. The riggers one, she was okay with. That showed her confidence. The one you can't do is the one where you call out by name a witness in this case that you know is going to testify and call him a coward and signal to him that he should change his testimony. And there's a perfect example from your own, which would have violated my gag order if it had been in place at the moment. So she reimposed the gag order. You did a hot taker. It's been on the Midas Touch Network with Alina Habba going on some Newsmax or right-wing thing saying, First Amendment, she'll never be able to put him in jail. What? Try it. Try it with Judge Chutkin. And she said, I'm going to evaluate on my own the next time something happens. It's brought to my attention. Either one of my staff or I catch it, or the prosecutors catch it because they're watching everything, and I'll evaluate on a case-by-case basis whether that does or does not violate, and then the appropriate remedy. And why is the remedy important, Ben? Because she is trying to accomplish something with the gag order. It's not a gag order, qua gag order, just to have a gag order. Hey, it's a novelty store. Here's a gag order. No. It is supposed to accomplish something, which is to protect in a prophylactic way the justice system from being interfered with, right, by Donald Trump in all of its components. And if she can't accomplish that with the threat of a gag, which is obvious that she can't, and she can't do it with a fine, because we can see from Judge Engoron in New York, fines don't matter. This guy has unlimited fine money that he's walking around with in his pocket from his donors. Then she has to come up with something else. And I'm sorry, Alina Habba, that something else is going to be a couple of days in the federal penitentiary, in the federal detention center. And if they think she's not, and they want to challenge that, I guess, and bring it to the U.S. Supreme Court's attention that the leading candidate is being jailed for his own conduct, then so be it. That we need that debate then. We need that discussion then. And we need a judge who's going to set him up for that. There is no way, and I'll leave it on this, Ben, there's no way between now and November, or the March trial, I'll leave it at the March trial, that he's not, Donald Trump, going to violate this order. And she's now going to have to sit there and think of an appropriate sanction in her toolbox to get that to never happen again.
Yeah, the gag order didn't come out of nowhere. It wasn't like the judge was like, we don't like Trump, therefore gag order. Donald Trump can't control himself. And there are tens of thousands, hundreds of thousands, maybe millions of litigants who all are supposed to follow the same rules. No one behaves like this. Nobody. I mean, he shows up in New York for 2.5 days and can't control himself, where he has to attack not just the judge, because the judge is okay with that. He has to attack the judge's law clerk and make up some lie that the judge's law clerk is having an affair with Chuck Schumer and post information about her online. Like, who does that? It's not a liberal, progressive, democratic thing for me to look at that and go, what in the world is that? I don't know if you saw this, and I'm not making this a political show per se, but you notice like Ken Buck from the Freedom Caucus said that he's not running again from Colorado. He's like, I don't recognize this party. From the Freedom Caucus. He goes, they don't believe that the 2020 election results are what they really are, that President Biden won. It's like, I can't be a part of this. That's why it's not really a partisan thing at all. It's just the behavior that he's engaging in is so disgraceful. It's embarrassing. You know, we should want to be a dignified nation and act like adults and behave ourselves like normal human beings. And he's acting like it is so bizarre. Just, there's no other way to describe it. It is so uniquely Trumpian, this out of control behavior that to me, it's not like, oh, that's conservative. No, that's just despicable. It's just pathetic. So let's just go to Colorado and let's talk about what's going on there. We're now past day 3 of the disqualification case in Colorado. That's going to trial. That case was filed early September. Also, a case was brought in Michigan. Donald Trump filed a lawsuit in Michigan to try to block the cases that are being filed in that state, requesting injunctive relief in Michigan. Meanwhile, he's in trial. He's not showing up for the trial, just like he didn't show up for Don Jr.'s testimony. He's not showing up for the disqualification case in Colorado. But the petitioners rested their case. Donald Trump's lawyers moved for a directed verdict, a motion to dismiss, kind of like what they tried to do in the New York Attorney General case after Cohen testified. Your Honor, we move to dismiss the case. And the judge in Colorado, just like Judge Engoron said, denied. So then Trump had to put on their case. Odd, they called Kash Patel, who continued to perpetuate that lie that Donald Trump wanted 10,000 National Guardsmen there, which we know is false. How do we know it's false, Ben? Because Donald Trump's Secretary of Defense, Chris Miller, testified under penalty of perjury that it was false, that there was never a request made for 10,000 National Guardsmen. There was some suggestion in the January 6th committee report that Donald Trump was envisioning a procession where he would basically storm the Capitol with the insurrectionists surrounded by military like Mussolini and seize power. That's where this idea, I suppose, was potentially floated, to protect him as he seized power. And then there's aides of his who said that they talked him out of that. But it never was a request for 10,000 National Guardsmen or people to protect the Capitol. That is false. I don't know what the benefit of having Kash Patel there is to testify at all. We may have a verdict, though, this week on the issue of disqualification in Colorado. And then I think all of these cases will wind their way up, I think, to the United States Supreme Court ultimately. And what'll be interesting about the timing is when the disqualification cases intersect with, I think, a guilty verdict that's going to be taken in the Washington, D.C. federal case. Because I think then on appeal, you know, with the disqualification case, you would say, look, he was just convicted in Washington, D.C. of federal crimes relating to the 2020 election. Popok, I'll leave you with the last word on disqualification.
Yeah, I like the judge in Colorado very much. I think she's running a tight ship. She understands the weight of history that's on her shoulders. She's taking it very seriously, unlike Donald Trump's team, who are literally almost phoning it in with these witnesses. I don't know where they learned this directed verdict trick. All they get is the judge. I mean, I get when you do it. I'm not saying it's not an appropriate thing to do in a courtroom. But the judge said, which is similar, as you said, a Judge Engoron in New York, no, there's issues left to be decided. I can't decide them based on the evidence that's only been presented so far on the plaintiff's side. I need to hear the rest. If I'm reading tea leaves, this judge is going to rule, because she's already decided that a judge has to make this decision. It's not something for Congress. It's not something for the Senate. It's not something for anybody, but a judge looking at the 14th Amendment, looking at the facts as developed in a trial for due process purposes, who makes the ultimate decision whether a person ends up on the ballot or not, or the Colorado Secretary of State gets to exercise her power. There's case law that we've talked about at length on Hot Takes. There's case law at the 10th Circuit, which covers Colorado, which including the leading case written by then Judge, now Justice Neil Gorsuch of the U.S. Supreme Court, who said point blank that the Colorado Secretary of State, who at the time is Trump's current lawyer, I love Trump doesn't do any due diligence or research about who he has as his front person in court. That guy was the Secretary of State in 2012 when he won his case to take a person off the ballot on a presidential ballot because he was not qualified. And of course, that case stands for the proposition that that's something appropriate for the Colorado Secretary of State. This judge has taken it seriously. She didn't ask for this case. She's taunted Donald Trump a little bit by saying, if you want to get rid of this disability under the 14th Amendment, Article 3, all you got to do is get 2/3 of the House and the Senate to to take it away from you. He could do it at any time, before the trial, after the trial, whenever. It was almost like she's like, we know you'll never get 2/3 of either house, so let's move on with the trial. I think she's going to ultimately rule that he can't be on the ballot. He's going to have to take something up to the Colorado Supreme Court, or try to take it to the 10th Circuit, fast track to the U.S. Supreme Court. I think the Michigan thing will fail, his attempt to kind of preemptively sue there or countersue there. These are important issues. When you and I a year ago talked about, what about the 14th Amendment disability clause? Why doesn't that apply? Yes, it came from the olden times, old-timey days of the Civil War and the reconstruction of the United States, about Civil War people. But why doesn't it apply? It's still on the books. And we were right. And then we said, then and now, it's not self-actuating. It is self-actuating, but you need a judge to kind of do the due process part. We saw a version of this. You and I talked about it a long time ago when they tried to take Marjorie Taylor Greene off the ballot. But that was some lower level administrative law judge that when he's not doing that, he tells you whether you're allowed to have your driver's license suspended back or not. So he was not the guy to handle this kind of case. And he was like, nope, I don't think so. I don't think that's how the 14th Amendment works. And she got to be on the ballot in Georgia. This is a real judge wearing a real black robe, not an administrative law judge making these decisions. So we don't talk a lot about it, but it is, just as the New York Attorney General case takes away, if successful, like a madcap game of Monopoly, Donald Trump's buildings, houses, money. I mean, this is like Mr. Monopoly. That case can do that. This case could be the glass ceiling breaker for other states to consider doing this if she rules that way. And by all indications, if I'm just being a court watcher here, she's going to ultimately rule that he is off the ballot and that he engaged in insurrection or rebellion, not convicted, engaged. That's what the term was. If the framers wanted to say convicted after due process, they would have said convicted after due process.
Store.MeidasTouch.com. We've got new merch, Popok. New merch, not just the LegalAF merch, which I absolutely love that you and Karen Friedman Agnifilo designed. We've also got the new Jack Smith collection, special counsel Jack Smith collection. We also got a few other special items, and we're telling you second, not first. First, we told our Patreon folks it was one of the benefits of joining patreon.com/MeidasTouch. They got first notice about all the new merch on store.MeidasTouch.com. You are now getting the second notice here for watching, and then we're going to make a big announcement about the new merch line in the next few days. But if you want to check it out, go to store.MeidasTouch.com. I mean, there's really cool stuff there that I think you all love. We spent a long time with these new designs, and I am super proud of it. If you want to get the first notice, that's patreon.com/MeidasTouch. It helps grow this independent media platform. And thank you to everybody who's separately got those YouTube memberships. You see the $ below. You can actually gift people memberships here, which unlocks the emojis by hitting that $. It's different than the Patreon, but it's that $ on the bottom of the YouTube chat. You can gift other people the emojis. We got the new Judge Engoron emoji. I mean, come on, who has Judge Engoron emojis? We don't have any outside investors, but we do have Judge Engoron emojis here at the Meidas Touch Network. I want to thank everybody so much for watching. LegalAF first, thank you. Please, if you have the ability, subscribe on audio. Just search LegalAF. Hit subscribe. It goes a long way in helping with the algorithm, in making sure that LegalAF becomes a top audio podcast in the news category, just like we are here on YouTube. It's free to do that. It takes you super quick to do that. So please, if you can, do that. We miss you, Karen Friedman Agnifilo, but we know you'll be back on the next episode. Keep doing those hot takes with Danya Perry, the duets. We love those. Popok and I will be back this weekend on LegalAF. I'll be here with my brothers on the Thursday night Meidas Touch podcast. We also got Mea Culpa, the Mea Culpa podcast officially now on our RSS feed as well. There's a new Mea Culpa RSS feed, so make sure you subscribe to that. I'll do a political beatdown with Michael Cohen in the morning or afternoon if you're on East Coast time. Popok, rest up, drink that orange juice, and a heavy dose of justice. I'm Ben Meiselas, joined by Michael Popok. Thank you all so much. We love you. We appreciate you. We're so grateful for you. Make sure you're registered to vote. Make sure that others in the pro-democracy community are registered to vote. Share LegalAF and this channel with everybody you know, and we'll see you next time on Legal AF. Shout out to the Midas Mighty.